Yes, thank you very much. Good morning. Thank you for this presentation. I will not have slides. I hate slides. I think people are looking at the slides and not listening to you. So I think it's much more difficult to actually try to entertain people and get their attention. But I'm up for the task, and I think I will make it. I would just like to start very briefly by just adding one thing so that you understand the perspective I'm talking from. As Aida mentioned, I wrote a PhD in international arbitration on the fair and equitable treatment published by OUP, so you can find it. And while I was doing my PhD, I worked with my supervisor, who is a very reputable arbitrator. I was actually kind of assisting him on the cases. He was appointed arbitrator. And then I worked for 5 years with the French law firm Gide in Poland on international arbitration cases. And after this experience, I felt that I was not really seeing the full picture of the disputes, because I had never been involved in the transactional side. I had been involved in once the dispute has been was on the table, but I did not know how were parties actually negotiating their transactional documentation, what was to be there in the negotiation table, what was the dispute actually coming from. So I asked to be involved more and more in M&A transactions just to get this experience, and I was lucky enough for my firm to accept that. So for the past 5 years, I had been involved in Central Eastern Europe in major transactions, cross-border transactions. So I'm speaking from this perspective, and I was just wanted to put this, to disclose this so that you know what is my view. And of course, now I have always been doing international arbitration, but now I'm kind of back. This experience has been completed for me. Of course, you can also have the pre-dispute position of the parties. You can always ask them how was it before you actually got to dispute, but I think it's never a very objective depiction of that phase. So my perspective is that of also this transactional experience which I had, and I will try to discuss this from this perspective. Well, if we take the topic of today, which is the outcome of arbitration, mediation, and litigation, I think we can all agree on the fact that you have two big categories of dispute resolution mechanism: the adjudicative ones, meaning you have a binding decision at the end, meaning arbitration, litigation, and the non-adjudicative ones, in which mediation is clearly included. And I will not address these outcomes from a comparative perspective. I will not try to see which one of the procedures is quicker or less costly, or which one of the outcome is actually easier to enforce. I will actually try to start a discussion from a rather different perspective, which is how can councils and tribunals contribute to finding a better outcome for the clients, not necessarily the outcome of arbitration, litigation, or mediation. And actually, from my experience, you don't really have one fitting it all, but not one method fitting all the disputes. But you really have to be to pay attention to the specificities of each one of the disputes. So what I will try to discuss, and of course there are probably 1,000 ways in which you can have a better outcome for the parties, but I will try to discuss if our mediation can be a way within an arbitral proceeding to try and find a better outcome for the parties. And I would like to make a disclosure. I don't think, I will only make it now at the beginning, but it will apply to my entire presentation. I don't think that every single arbitration procedure has to have a mediation phase. Absolutely not. I mean, the cases in which you feel that the parties are ready for it and that the dispute is adapted to this kind of mediation integration are very rare. So I'm just talking about, keeping this in mind as a possibility, but it's certainly not, I don't want to have any general comment on that, because it definitely does not apply to all arbitration proceedings. So I will start from actually two illustrations of what I think that the parties do not always have the same idea or perception of the outcome they are expecting from a dispute resolution. And I will have two illustrations for that. The first one is a study by the Global Pound Conference series, which you may know. They made a study in which they asked over 8,000 participants, both practitioners and parties, what is their outcome, what is the outcome that they are looking for when they start a dispute in a commercial dispute. And actually, the results were that they found almost ex aequo. The answers were the financial compensation. We are looking for a financial result, meaning a compensation or damages, and we are looking for actually an action focused, meaning we are trying to have the other party do something or not do something. And the third, as a third on the ranking, came a psychological outcome. We want vindication, or we just want to be heard. We just want procedural fairness. And finally, of course, you had the relationship-focused answer, meaning we would like to terminate or to continue the relationship. So clearly, the parties, when they start a dispute, they are not looking for the same outcome, and this is something that one has to take into account. The second illustration of this, of the fact that parties are not looking for the same outcome, I will use the example given to me by a very famous arbitrator who has a lot of experience. He was a counsel and he was representing a state in an investment arbitration. He was the counsel for the state, and the award gave half of the compensation asked for to the investor. Of course, everybody would see this as a success for the investor, and he was representing the state. Well, the state thought, well, the bill could be double, so I'm happy that it's only half of it, and they were ready to pay as soon as possible to avoid actually interests. So the counsel of the state calls his counterpart, the counsel of the investor, to try to speak technicalities about the payment. And actually, he finds out that his counterpart, the counsel of the investor, had been fired with immediate effect, because the investor thought this was a major loss and that this was absolutely not what they were expecting, so he was absolutely fired. So the outcome that the parties are looking for when they come to arbitration, the perception that they have of a good outcome, it's clearly a case-by-case issue, and you really have, as a counsel, to have that psychological sixth sense, if I can say, to try and find the better outcome, the best outcome possible for your client. Having said this, I think that we also see, at least in the part of the world where I practice, more and more settlements, which means that in a way the parties don't feel anymore that the classical, if I can say, ways of resolving disputes, meaning arbitration or litigation or mediation, are the best. So with this in mind, what I will try to very briefly go through is how can we, in practice, use mediation in an arbitral proceeding? First of all, I will see what would be the positive impact of using mediation. Then I will discuss at what stage exactly of the procedure one could use mediation. I would also look at what are the triggers of mediation in an arbitral proceeding. And of course, I will look at what everybody, or at least we are all looking very highly at, which is the outcome. What can be the outcome of such a procedure in which you are using mediation? Well, first of all, in terms of what can be the positive impact of mediation in an arbitral proceeding, I think we all agree that in a dispute you, of course, have the objective facts, which are the facts, the law, the position of the parties, which are the objective elements of the dispute. And yesterday there was a lot of the discussion about that you have a lot of subjective elements. You have the cultural positions, you have the interests of the party, you have their fears, you have the business relationship of the parties. And if you look at arbitration, clearly what an arbitrator is asked to do is to decide who is right and wrong, and to establish the facts, to establish the law, and to take a decision. So the arbitral award, in a way, is really something which takes into account the objective elements of a dispute, meaning the facts, the law, and the positions of the parties. Whereas in mediation, the mediator, the neutral, actually is trying to find a solution, looking into the future, looking at it to the parties, trying to have the parties reaching a conclusion in which, I have to say, the subjective elements of the dispute are very much highlighted. I read a study which was discussing, it was a medical study discussing what parts of the brain are used by the arbitrator and in the mediator while actually in a dispute. And it's true that an arbitrator uses the left part of the brain the most, meaning the one which is rational, the one which is really about analytical part of the dispute, whereas in mediation it is more the right part of the brain, the one which is the creative side of the brain, which is more more used. So the first positive impact that I would see in using mediation is that you are able to look or to introduce in the outcome of the dispute the subjective parts of a dispute, which it's a little bit more difficult in an arbitration setting. Well, the second one, second positive outcome is clearly that arbitration is becoming more and more lengthy, more and more costly. I think we all agree on that. Studies have shown that by using mediation at a certain stage of the dispute is actually making the procedure less costly and a little bit shorter. And of course, business relationship can be preserved usually. And finally, a mediated solution is much more likely to be accepted by the parties because actually they have been much more involved in reaching it than in arbitration or litigation. Again, I'm talking about the cases where the parties are ready for it, where the dispute at stake actually allows you to use mediation. Again, it is not a generalized way of proceeding in an arbitration proceeding. Now, what are the stages where you could use arbitration? I think there are 3 stages in which you can use mediation. I think there are 3 stages. The first one is clearly the preliminary phase, then during the arbitral proceeding, and then finally at the enforcement phase. Well, preliminary, I think this is what is more classical, what we see the most often, where the parties agree that they will make the best efforts to find a solution to the case based on mediation. If mediation fails, then they will go to arbitration or litigation, depending on their clause. I have to say that a failure of the mediation phase, at least in our experience, is not really a failure. And clients have been praising 2 things on this in this case. In a case in which they tried to reach a mediation solution that did not manage, and then we had to go to arbitration. The first one is very much connected to the way in which companies are structured, meaning you have the operationals on the field negotiating the transactions. They are the ones who are in contact with the other party. They have all the historical background, and then it's only the moment when the dispute arises that the litigation department or the legal department is usually involved. Of course, you have the legal department sometimes involved in the transactional phase as well, but it's true that as the dispute resolution, the dispute department or the legal department gets involved only when the dispute is on the table. Of course, they're unaware of the case. They're unaware of the transaction. They have to actually find out what this is all about, what has happened before. And this mediation phase actually helps the parties in certain cases to just internally be put up to date with the situation, try to identify who are the parties whom they can use internally in this dispute, what are the documents that they have at stake. So in a way, it's a preparation that they are having for the actual arbitration. And the second point which we found useful in the mediation, that actually the clients agree, is that very often when you have a dispute, you are, of course, trying to fight on every single front. You have a feeling that every single point is a litigious point and the other party will not agree on anything. And actually on mediation, when you are having the option and the possibility to talk to the other party, you realize on a couple of points, actually, you agree. So you narrow down the questions on which you are going to fight to the ones which are actually really in contradiction between the 2 parts. And I think this is extremely important, and we were talking about delays in process. I mean, why would you do a huge memorial trying to fight every single one of the points when you can actually agree that there are only 2 or 3 points you disagree on, and let's focus on that. So narrowing down the issues at stake, if the parties are able to discuss beforehand, I think it's an extremely important point. Now, during the procedure, so this is the preliminary phase when mediation can be used. If it's successful, very good. If it's not successful, I don't see it as a failure because this would be the advantages that we see in it. During the arbitral procedure, of course, you can use you can use mediation before the commencement of the arbitration, but before actually the hearing on the merits. The objective of this would be to narrow down the issues, I think, at stake. Then you can also use it, of course, after the hearing on the merits. In this case, you would reach a settlement. Or in parallel with arbitration, we see this, of course, quite a lot. Finally, I think you can use it at the enforcement phase, and this is something which was quite new to us. Well, we have all discussed yesterday about the fact that, of course, it is important to be able to enforce a decision procedurally, but once it's enforced procedurally, well, you still have to be paid, right? And this is the most difficult part of the discussion. And of course, using mediation at the enforcement level, what I mean by that is that you have an award and the other party refuses to comply with it. Well, what can you do? Well, what we saw is that mediation helps you to find a compromise. So you have on the table the award and you know what would be, let's say, right. So by law you are entitled to a certain amount. But in reality, the other party does not want to pay. So finding a compromise based on this award, it's something which in practice we found very useful. The way in which we used this was in an investment arbitration in Africa, and the state was clearly not willing to pay. But we managed to find by mediation a solution in which a part was paid, and then the other part was actually invested by the state in a project, ongoing project of the client. So this, of course, again, it's so typical for this particular case, meaning our investor, our client, was very much involved in the state. They had a lot of ongoing projects. It was not a case where there was nothing going on and they just wanted to leave the country and they had no other. So there was really a question of relationship, of business relationship, of economic interests of the client. And so this mediation used at the enforcement phase, we found it extremely useful. Again, for the cases for which you can actually use that. What triggers the use of mediation? Well, obviously, the councils, the parties can have this idea. The arbitrators sometimes can actually tell the parties that they can use mediation, and of course also the contractual provisions that you have put in your contract. Being said, of course, that the question of should the arbitrator be also the mediator, or would you actually need a third-party mediator? It's a question I'm not going to discuss, but of course it's an interesting question. In terms of the contractual clauses, well, we see most of the arbitral institutions are offering model clauses. I'm not going to develop on that, but I'm going to say that, of course, you have the usual model clause saying that we will try to use mediation prior to arbitration, but you also have the so-called ARB, Med, ARB, so arbitration, mediation, arbitration, in which you have model clauses saying that once you started the arbitration, you can use mediation, and the mediation settlement, if there is one, can be included in a consent award of the tribunal. And actually, this leads me to the outcome. What could be the outcome if you use mediation in arbitration? Well, first of all, you can have a mediation settlement agreement, clearly, but the value of that is that of a contract. So if the other party decides not to respect it, there is a breach of contract, well, the only solution you have is litigation again. So you're back on the track of litigation. And there is no unified mechanism of enforcing mediation settlement agreements, which, of course, is one of the weaknesses of mediations. Then you have the consent award, which basically incorporates the mediation solution of the parties in an award with the obvious strength that you can enforce it with the New York Convention. And then the last point I would like to make on the possible outcomes is the European Directive 2008-52 EC, which actually allows, in the member states which actually have implemented this directive, allows the mediation settlement to be included in a judgment or in a product which has the value of a judgment. And this in different cases, in different states, depending on how they implemented this, it can be done at the request of the two parties or the one party with the consent of the other. So this mediation settlement which is included in a judgment, I think it's also something to keep in mind, at least in the European Union. So these are the points I wanted to share with you on the topic. I would not like to be longer on that. I honestly do not think that in the current development of arbitration, litigation, and mediation, one should look at them as totally exclusive from each other. I think that the parties are more and more willing to look at creative solutions, and this is the bridge to Virginie. And I think that we as councils really have the responsibility of before we are throwing ourselves in one of litigation or arbitration or mediation, to really stand for a second and see what could be the best for the client and what could we offer as a creative option. Thank you very much.
Thank you.